reading the restatement of contracts second. We're going to finish the second before we get to the third. All in this recording, no less. Topic 3 is where we begin on page 250 of the selections for contracts 2016 edition. Topic 3 is the effect of prospective non-performance. So section 250, titled When a Statement or an Act is a Repudiation, is where we begin defining a repudiation as a statement by the obligor to the obligee indicating that the obligor will commit a breach that would of itself give the obligee a claim for damages for total breach under section 243, or B, a voluntary affirmative act which renders the obligor unable or apparently unable to perform without such a breach. So it's either a statement or a voluntary affirmative act indicating that performance under the contract isn't looking likely. Section 251. When a failure to give assurance may be treated as a repudiation. 1. Where reasonable grounds arise to believe that the obligor will commit a breach by non-performance that would of itself give the obligee a claim for damages for total breach under section 243, the obligee may demand adequate assurance of due performance and may, if reasonable, suspend any performance for which he has not already received the agreed exchange until he receives such assurance. And 2, when failure to give assurance may be treated as a repudiation, the obligee may treat as a repudiation the obligor's failure to provide within a reasonable time such assurance of due performance as is adequate in the circumstances of the particular case. Section 252, effect of insolvency. Where the obligor's insolvency gives the obligee reasonable grounds to believe that the obligor will commit a breach under the rule stated in 251, an obligee may suspend any performance for which he has not already received the agreed exchange until he receives assurance in the form of performance itself and offer of performance or adequate security. And 2, a person is insolvent who either has ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due or is insolvent within the meaning of federal bankruptcy law. Section 253, effect of a repudiation as a breach and on other parties' duties. 1. Where an obligor repudiates a duty before he has committed a breach by non-performance and before he has received all of the agreed exchange for it, his repudiation alone gives rise to a claim for damages for total breach. 2. Where performances are to be exchanged under an exchange of promises, one party's repudiation of a duty to render performance discharges the other party's remaining duties to render performance. Section 254, effect of subsequent events on duty to pay damages. 1. A party's duty to pay damages for total breach by repudiation is discharged if it appears after the breach that there would have been a total failure by the injured party to perform his return promise. And 2. A party's duty to pay damages for total breach by repudiation is discharged if it appears after the breach that the duty he had repudiated would have been discharged by impracticability or frustration before any breach of non-performance. Again, that's the effect of subsequent events on duty to pay damages. So, a party's duty to pay damages for total breach by repudiation is discharged if it appears after the breach that there would have been a total failure by the injured party to perform his return promise. And 2, a party's duty to pay damages for total breach by repudiation is discharged if it appears after the breach that the duty that he repudiated would have been discharged by impracticability or frustration before any breach of non-performance. Section 255, effective of repudiation as excusing the non-occurrence of a condition. Where a party's repudiation contributes materially to the non-occurrence of a condition of one of his duties, the non-occurrence is excused. Again, where a party's repudiation contributes materially to the non-occurrence of a condition or one of his duties, the non-occurrence is excused. I just read this out of the conditions section. And I don't know what it means because it doesn't sound right. Where a party's repudiation contributes materially to the non-occurrence of a condition of one of his duties, the non-occurrence is excused. So the condition is excused to the non-occurrence of a condition of one of his duties. So I suppose if this was a construction contract and we needed to get inspections periodically, if one of those inspections fail, you don't necessarily continue with the contract. That's the stretch. Anyway, section 256, nullification of repudiation for basis for repudiation. The effect of a statement as constituting a repudiation under section 250 or the basis for a repudiation under 251 is nullified by a retraction of the statement if notification of the retraction comes to the attention of the injured party before he materially changes his position and reliance on the repudiation or indicates to the other party that he considers the repudiation to be final. So when you repudiate, the other party doesn't have to perform, or they can suspend their performance. If they go and sign a contract with somebody else to cover, say, the goods, or, replace the performance that you have repudiated and thus has changed his position in reliance on your repudiation, then you can't nullify your repudiation. However, you can if that other party, the non-breaching party, has not changed his position in reliance on the repudiation. And 2, under the nullification of repudiation section, the effect of events other than a statement as constituting repudiation under section 250, as we said, is a voluntary something act, voluntary affirmative act under 250, or the basis for a repudiation under section 251 is nullified if, to the knowledge of the injured party, those events have ceased to exist before he materially changes his position in reliance on the repudiation or indicates to the other party that he considers the repudiation to be final. So, in other words, if Trump wants to change tariff by a certain date and then miraculously that doesn't happen, then that should be enough for the injured party to then not change his position and reliance on the repudiation that may have occurred as a result of impracticability from a tariff change, which actually wouldn't be impracticable. It would be impracticable. It wouldn't be impossible, and might not actually suffice as impracticability because it's only economic, but that's besides the point. Section 257, effective urging performance in spite of repudiation. The injured party does not change the effect of repudiation by urging the repudiator to perform in spite of his repudiation or to retract his repudiation. Anyway, topic 4, application of performances. Section 258, obligor's direction of application. Except as stated in subsection 2, as between two or more contractual duties owed by an obligor to the same obligee, a performance is applied according to the direction made by the obligor to the obligee at or before the time of performance. If the obligor is under a duty to a third person to devote performance to the discharge of a particular duty that the obligor owes to the obligee, and the obligee knows or has reason to know this, the obligor's performance is applied to that duty. Creditor's application, section 259. Except as stated in subsections 2 and 3, if the debtor has not directed application of a payment as between two or more matured debts, the payment is applied according to a manifestation of intention made within a reasonable time by the creditor to the debtor. 2. A creditor cannot apply such a payment to a debt if the debtor could not have directed its application to that debt, or a forfeiture would result from a failure to apply it to another debt, and the creditor knows or has reason to know this, or C, the debt is disputed or is unenforceable on grounds of public policy. And 3rd, under creditor's application, which is if the debtor has not directed application of a payment as between two or more matured debts, the payment is applied according to the manifestation of intention made within a reasonable time by the creditor to the debtor, except 3, if a creditor is owed one such debt in his own right and another in a fiduciary capacity, he cannot, unless empowered to do so by the beneficiary, effectively apply to the debt in his own right a greater proportion of the payment than that borne by the unsecured portion of that debt to the secured portion of both claims. It's interesting, not important for the exam I'm taking tomorrow. Section 260, application of payments where neither party exercises his power. If neither the debtor nor the creditor has exercised his power with respect to the application of a payment as between two or more matured debts, the payment is applied to debts to which the creditor could have applied it with just regard to the interests of third persons, the debtor and the creditor. In applying payments under the rules stated in subsection 1, a payment is applied to the earliest matured debt and ratably among debts of the same maturity, except that preference is given A, to a debt that the debtor is under a duty to a third person pay immediately, and B, if he is not under such a duty, to overdue interest rather than principal, and 2, to an unsecured or precarious debt rather than one that is secured or certain of payment. I find that wildly interesting as a banker, so I'm going to flag it in a wildly interesting color. Anyway, chapter 11, impracticability of performance and frustration of purpose. So this is what I alluded to earlier. Maybe we can shed some light on it. Discharge by supervening impracticability is section 261, where after a contract is made, a party's performance is made impracticable without his fault or by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made. His duty to render that performance is discharged unless the language or the circumstances indicate the contrary. Unless it's expressed in the contract how we're going to handle the occurrence of an event, that the non-occurrence of which was the basic assumption on which the contract was made. Right? Section 231, 61. Death or incapacity of person necessary for performance. If the existence of a particular person is necessary for the performance of a duty, his death or such incapacity makes performance impracticable is an event the non-occurrence of which was a basic assumption on which a contract was made. Destruction, deterioration, or failure to come into existence of thing necessary for performance. Section 263. If the existence of a specific thing is necessary for the performance of a duty, its failure to come into existence, destruction, or such deterioration as makes performance impracticable is an event the non-occurrence of which was a basic assumption on which the contract was made. Section 261 or 264. Prevention by governmental regulation or order. If the performance of a duty is made impracticable by having to comply with a domestic or foreign governmental regulation or order, that regulation or order is an event, the non-occurrence of which was a basic assumption on which the contract was made. And again, we've read somewhere that it has to be legal at the time of the confirmation and then subsequently become illegal. Section 265, discharge by supervening frustration, where after a contract is made, a party's principal purpose is substantially frustrated without his fault by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made. His remaining duties to render performance are discharged unless the language or the circumstances indicate the contrary. So, Section 266, existing impracticability or frustration, where at the time a contract is made, a party's performance under it is practicable without his fault because of a fact of which he has no reason to know, and the non-existence of which is a basic assumption on which the contract is made. No duty to render that performance arises unless the language or circumstances indicate the contrary. And to where at the time that contract is made, a party's principal purpose is substantially frustrated without his fault by the fact he has no reason to know, and the non-existence of which is the basic assumption on which the contract is made. No duty of the party to render performance arises unless the language or circumstances indicate the contrary. Okay, so I'm marking anticipatory repudiation. And I'm going to mark also impracticability. Might be worthwhile to spend some time going back and reading the comments and illustrations at another time. That might come up before the final tomorrow. Section 267. Effect on other parties' duties of a failure justified by impracticability or frustration. 1. A party's failure to render or to offer performance may, except as stated in subsection 2, affect the other party's duties under the rules stated in section 237 and 238, even though the failure is justified under the rules stated in this chapter. The rule stated in subsection 1 does not apply if the other party assumed the risk that he would have to perform despite such a failure. So, section 268, effect on other parties' duties of a prospective failure justified by impracticability or frustration. A party's prospective failure of performance may, except as stated in subsection 2, discharge the other party's duties or allow him to suspend performance under the rules stated in section 251 and 253, 251.1 and 253.2, even though the failure would be justified under the rules as stated in this chapter. And the rule stated in subsection 1 does not apply if the other party assumed the risk that he would have to perform in spite of such a failure. Section 269, temporary impracticability or frustration. Impracticability, a performance or frustration of purpose that is only temporary, suspends the obligor's duty to perform while the impracticability or frustration exists, but does not discharge its duty or prevent it from arising unless its performance after the cessation of the impracticability or frustration would be materially more burdensome than had there been no impracticability or frustration. Section 270, partial impracticability. Where only part of an obligor's performance is impracticable, his duty to render the remaining part is unaffected if it is still practicable for him to render performance that is substantial, taking account of any reasonable substitute performance that he is under a duty to render, or the obligee B, within a reasonable time, agrees to render any remaining performance in full and to allow the obligor to retain any performance that has already been rendered. Section 271, impracticability as excuse for non-occurrence of a condition. Impracticability excuses the non-occurrence of a condition if the occurrence of the condition is not a material part of the agreed exchange and forfeiture would not result. And Section 272, relief including restitution. In any case governed by the rules stated in this chapter, either party may have a claim for relief including restitution under the rules stated in 240 and 377. In any case governed by the rules stated in this chapter, if those rules together with the rules stated in Chapter 16 will not avoid injustice, the court may grant relief on such terms as justice requires, including protection of the party's reliance interest. Chapter 12, discharge by assent or alteration. So, discharge is going to be a big part of this test tomorrow. So, are the rest of the sections. So let's continue. Section 273, requirement of consideration or a substitute. Except as stated in Section 274 through 77, an obligee's manifestation of assent to a discharge is not effective unless it is made for consideration, A. B. It is made in circumstances in which a promise would be enforceable without consideration, or C. It has induced such action or forbearance as would make a promise enforceable. Section 274, cancellation, destruction, or surrender of a writing. An obligee's cancellation, destruction, or surrender to the obligor of a writing of a type customarily accepted as a symbol or as evidence of his right discharges without consideration the obligor's duty if it is done with the manifestation intended to discharge it. Section 275, assent to discharge duty of return performance. If a party, before he has fully performed his duty under a contract, manifests to the other party his assent to discharge the other party's duty to render part or all of the agreed exchange, the duty is to that extent discharged without consideration. Section 276, assent to discharge duty to transfer property. Section 277, renunciation. A written renunciation signed and delivered by the obligee discharges without consideration a duty arising out of a breach of contract. And 2, a renunciation by the obligee on his acceptance from the obligor of some performance under a contract discharges without consideration a duty to pay damages for a breach that gives rise only to a claim for damages for partial breach of contract. Topic 2, substituted performance, substituted contract, accord and account stated. Substitute performance. Section 278. 1. If an obligee accepts in satisfaction of the obligor's duty a performance offered by the obligor that differs from what is due, the duty is discharged. If an obligee accepts in satisfaction of the obligor's duty a performance offered by a third person, the duty is discharged. But an obligor who has not previously assented to the performance for his benefit may, in a reasonable time after learning of it, render the discharge inoperative from the beginning by disclaimer. Section 279, Substituted Contract. A substituted contract is a contract that is itself accepted by the obligee in satisfaction of the obligor's existing duty. And 2, the substituted contract discharges the original duty, and breach of the substituted contract by the obligor does not give the obligee a right to enforce the original duty. Section 280, a novation is a substitute contract that includes a party one who was neither the obligor nor the obligee of the original duty. Accord and satisfaction, section 281. An accord is a contract under which an obligee promises to accept a stated performance in satisfaction of the obligor's existing duty. Performance of the accord discharges the original duty. 2. Until performance of the accord, the original duty is suspended unless there is such a breach of the accord by the obligor as discharges the new duty of the obligee to accept the performance in satisfaction of the accord, in addition to any claim for damages for partial breach. Did I just read 1, 2, and 3? Alright, let's try that again. An accord is a contract under which an obligee promises to accept a stated performance in satisfaction of the obligor's existing duty. Performance of the accord discharges the original duty. 2. Until performance of the accord, the original duty is suspended unless there is such a breach of the accord by the obligor as discharges the new duty of the obligee to accept the performance and satisfaction. If there is such a breach, the obligee may enforce either the original duty or any duty under the accord. And 3rd, breach of the accord by the obligee does not discharge the original duty, but the obligor may maintain a suit for specific performance of the accord in addition to any claim for damages for partial breach. And section 282, accounts stated. Let it be known that accord is the contract, but satisfaction is after that second contract has been performed. Satisfaction then occurs and discharges the original duty. So the accord and satisfaction are two different parts to this to discharge of an original duty under accord and satisfaction in this topic. Section 282, account stated. 1. An account stated is a manifestation of assent by debtor and creditor to a stated sum as an accurate computation of an amount due the creditor. A party's retention without objection for an unreasonably long time of a statement of account rendered by the other party is a manifestation of assent. And 2, the account stated does not itself discharge any duty, but is an admission by each party of the facts asserted and a promise by the debtor to pay according to its terms. Topic 3, agreement of rescission, release, and contract not to sue. Section 283, agreement of rescission. An agreement of rescission is an agreement under which each party agrees to discharge all of the other's remaining duties of performance under an existing contract. An agreement of rescission discharges all remaining duties of performance of both parties. It is a question of interpretation whether the parties also agree to make restitution with respect to performance that has been rendered. 284, release. A release is a writing providing that a duty owed to the maker of the release is discharged immediately or on the occurrence of a condition. 2. The release takes effect on delivery as stated in section 101-03 and subject to the occurrences of any condition discharges the duty. Now, Section 2E5, contract not to sue. A contract not to sue is a contract under which the obligee of a duty promises never to sue the obligor or a third person to enforce the duty or not to do so for a limited time. 2. Except as stated in subsection 3 to come. A contract never to sue discharges the duty, and a contract not to sue for a limited time bars an action to enforce the duty during that time. And 3, which is the exception, a contract not to sue, one co-obligor bars levy of execution on the property of the promisee during the agreed time, but does not bar an action or the recovery of judgment against any co-obligor. Interesting. Alteration, topic 4. Alteration of writing, section 286. If one to whom a duty is owed under a contract alters a writing that is an integrated agreement or that satisfies the statute of frauds with respect to that contract, the duty is discharged if the alteration is fraudulent and material. Number 2 under section 286, still alteration of writing. An alteration is material if it would, if effective, vary the party's legal relations with the marker of the alteration or adversely affect that party's legal relations with the third person. The unauthorized insertion in a blank space in a writing is an alteration. Section 287, assent to or forgiveness of alteration. If a party, knowing of an alteration that discharges his duty, manifests assent to the altered terms, his manifestation is equivalent to an acceptance of an offer to substitute those terms. And 2, if a party knowing of an alteration that discharges his duty asserts a right under the original contract or otherwise manifests a willingness to remain subject to the original contract or to forgive the alteration, the original contract is revived. Okay, chapter 13, joint and several promisors and promisees. I'm going to skip this. Joinder is a nice word. I haven't heard in a little while. Joint and several promisees. Topic 2. And we'll move to chapter 14, contract beneficiaries. This is section 302, discussing intended and incidental beneficiaries. Unless otherwise agreed between promisor and promisee, a beneficiary of a promise is an intended beneficiary if recognition of a right to performance in the beneficiary as appropriate to effectuate the intention of the parties, and either A, the performance of a promise will satisfy an obligation of the promisee to pay money to the beneficiary, or B, the circumstances indicate that the promisee intends to give the beneficiary the benefit of the promised performance. And 2, under intended and incidental beneficiaries. An incidental beneficiary is a beneficiary who is not an intended beneficiary. Section 303, conditional promises, promises under seal. The statements in this chapter are applicable to both conditional and unconditional promises and are sealed and unsealed promises, and to both sealed and unsealed promises. Section 304, creation of a duty to beneficiary. A promise in a contract creates a duty in the promisor to any intended beneficiary to perform the promise, and the intended beneficiary may enforce the duty. Section 305, overlapping duties to beneficiary and promisee. 1. A promise in a contract creates a duty in the promisor to the promisee to perform the promise, even though he also has a similar duty to an intended beneficiary. And 2, whole or partial satisfaction of the promisor's duty to the beneficiary satisfies to that extent the promisor's duty to the promisee. Section 306, disclaimer by a beneficiary. A beneficiary who has not previously assented to the promise for his benefit may, in a reasonable time after learning of its existence and terms, render any duty to himself inoperative from the beginning by disclaimer. Section 307, remedy of specific performance. Where specific performance is otherwise an appropriate remedy, either the promisee or the beneficiary may maintain a suit for specific enforcement of a duty owed to an intended beneficiary. So either the promisee or the beneficiary may maintain a suit for specific enforcement of a duty owed to an intended beneficiary. Section 308, identification of beneficiaries. It is not essential to the creation of a right in an intended beneficiary that he be identified when the contract containing the promise is made. As long as not given here, he can be identified at the time the performance is due. Section 309, defenses against the beneficiary. A promise creates no duty to a beneficiary unless a contract is formed between the promisor and the promisee, and if a contract is voidable or unenforceable at the time of its formation, the right of any beneficiary is subject to the infirmity. 2. This is defenses against the beneficiary. Again, promise creates no duty to a beneficiary unless a contract is formed between a promisor and the promisee, and if a contract is voidable or unenforceable at the time of its formation, the right to any beneficiary substituted is subject to the infirmity. 2. If a contract ceases to be binding in whole or in part because of impracticability, public policy, non-occurrences of the condition, or present or prospective failure of performance, the right of any beneficiary is to that extent discharged or modified. And 3. Except as stated in subsection 1 and 2 and in section 311, or as provided by the contract, the right of any beneficiary against the promisor is not subject to the promisor's claims or defenses against the promisee, or to the promisee's claims or defenses against the beneficiary. So, reading that again, unless 1 or 2, or section 111, which is the variation of a duty to a beneficiary, except in those cases, or as provided by the contract, the right to any beneficiary against the promisor is not subject to the promisor's claims or defenses against the promisee, or to the promisee's claims or defenses against the beneficiary. And 4, a beneficiary's right against the promisor is subject to any claim or defense arising from his own conduct or agreement. And that's section 309, defenses against the beneficiary. Section 310, remedies of the beneficiary of a promise to pay the promisee's debt, reimbursement of promisee. 1. Where an intended beneficiary has an enforceable claim against the promisee, he can obtain a judgment or judgments against either the promisee or a promisor, or both based on their respective duties to him. Satisfaction whole or in part of either of these duties or of a judgment thereon satisfies to that extent the other duty or judgment subject to the promisee's right of subrogation. And 2, to the extent that a claim of an intended beneficiary is satisfied from assets of the promisee has a right of reimbursement from the promisor, which may be enforced directly, and also, if the beneficiary's claim is fully satisfied, by subrogation to the claim of the beneficiary against the promisor, and to any judgment thereon, and to any security therefore. Alright, so I'm probably going to reread section 309, 310, and 311 at least, but let's go on to 311. I'll take a break and reread it. 1. Discharge or modification of a duty to an intended beneficiary by conduct of the promisee, or by a subsequent agreement between promisor and promisee, is ineffective if a term of the promise creating the duty so provides. 2. In the absence of such term, a promisor and promisee retain power to discharge or modify the duty by subsequent agreement. And 3, such a power terminates when the beneficiary, before he receives notification of discharge or modification, materially changes his position in justifiable reliance on the promise or bring suit on it or manifest assent to it at the request of the promisor or promisee. And fourth, if the promisee receives consideration for an attempted discharge or modification of the promisor's duty which is ineffective against the beneficiary can assert a right to the consideration so received. The promisor's duty is discharged to the extent of the amount received by the beneficiary. I guess we can finish this topic. Section 312, mistakes as to duty to beneficiary. The effect of an erroneous belief of the promisor or promisee as to the existence or extent of a duty owed to an intended beneficiary is determined by the rules making contracts voidable for mistake. Section 313, government contracts. 1. The rules stated in this chapter apply to contracts with a government or governmental agency except to the extent that application would contravene the policy of the law authorizing the contractor prescribing remedies for its breach. Did I read? The effect of an erroneous belief, again, back to mistake, as to duty to beneficiary. The effect of an erroneous belief of the promisor or promisee as to the existence or extent of a duty owed to an intended beneficiary is determined by the rules making contracts voidable for mistake. Section 313, government contracts. The rules stated in this chapter apply to contracts with the government or governmental agency except to the extent that application would contravene the policy of the law authorizing the contractor prescribing remedies for its breach. Number 2, in particular, a promisor who contracts with a government or governmental agency to do an act for or render a service to the public is not subject to contractual liability to a member of the public for consequential damages resulting from performance or failure to perform unless A or B, A, the terms of the promise provide for such liability, or B, the promise is subject to liability to the member of the public for the damages, and a direct action against the promisor is consistent with the terms of the contract and with the policy of the law authorizing the contract and prescribing remedies for its breach. Section 314, suretyship defenses. An intended beneficiary who has an enforceable claim against the promisee is affected by the incidence of the suretyship of the promisee from the time he has knowledge of it. And Section 315, effect of a promise of incidental benefit. An incidental beneficiary acquires by virtue of the promise no right against the promisor or the promisee. So we break here.